The next petition, which is item 12 on the agenda, by a German person who wants not to refrain from disclosing his name. It's on enforcement of a court judgment so as to allow him to exercise his visitation rights with his child. The petitioner is here, and I'm happy to give you the floor for 5 minutes.
Okay. Hello, good afternoon. I would come to the petition of my child who has been brought from the mother to UK, and since then there is nearly no contact. On the screen you can see a total overview what happened up to the time when the child was born. Before I start and go into this, a similar point, or a simple question. When there is a discussion about a child not wanting to go to school, I don't think that issues come up. It's very clear that this child has to go to school. The state will bring this up. But when we have discussions of a child saying he or she does not want to see a parent, it's getting much more difficult. And I don't really understand why there is such a big difference. Especially, could it be that children are influenced from one parent or from somebody else that this stops? Okay, so coming back to the petition and my child, last time when we stopped, there was the decision that the Commission has to write a letter to the to UK. Up to now, I don't think this has happened. Okay, coming to the issues. My child was born in 2004. Around 2007, we had already court proceedings, and we tried to do it in a nice way. The Maltese courts finally decided to put court marshals and social workers, not because the father was dangerous, but just to make sure that this child has paternal contact. That means that this child sees the father. When the father was coming from Germany and arrived, it happened not there. Mother said she did not know, etc., etc. In 2009, the mother was allowed to bring the child temporarily to UK for 1 year. And immediately after the child arrived in UK, I had no contact information, no address. It took 4 months until she was found. At this time, that's a Brussels 2A regulated order. International Family Justice, it's coming into the loop. Matthew Thorpe was responsible for these issues. At 2010, I informed first written and then personally the European Commission about the situation that I have no contact. I'm an engineer, I'm not a lawyer, so I don't have especially at this time, I did not have a deep background about law. What I found at this time, because the mother was found, I have received bills of £18,000. It seems in UK it's a real money machine. That means I had an international valid order, but still I received bills of £18,000 to find a child and trying to get contact. After 3 months I had stopped because I couldn't afford this. 1 year later, that was in 2010, the mother was not allowed anymore to keep the child in UK because the stay had expired, and still I had no contact, so my last option was to take him out of the country. That was half a year later in 2011. And again, the child definitely did not feel good about a father who takes him out of the school in his life and saying, hey, you have to go. But that was my last option to see my child. And mediation, we had discussions, but the rule was not followed. In 2011, we had a second abduction. That means the mother was again allowed to go to UK. She did not return. And at this time I said, because the first time I had taken him out of the child, I will try whatever possible to enforce the law in UK. That means to enforce Brussels II, to enforce a Maltese order for contact, for 5 days a night contact, to see my child. We went ahead at courts. There was no big progress. In 2013, UK has taken jurisdiction, and there was a decision from Malta that they did not want that UK takes jurisdiction, but at the end they have taken it. And in 2015, that means when I got now to know how it should have worked, UK rejected my request. It was still possible to appeal after 2 years for a preliminary ruling in Luxembourg at the court. Still I have no contact. To go in more detail, in 2013, when UK has taken jurisdiction, psychologist was nominated, and the case was returned. Then father request, wait a moment, sorry, I need to hurry up a little, I'm aware. So there was a psychologist nominated, then was a child specialist. After 1 year, still no progress. I went back to court, said, hey people, it can't be that I see my child just for 1 hour when I come to London and that every 3 months. Nothing happened. 1 year later, that was in 2015, I tried to get rid, sorry to say it in this way, of this judge, because since 2013 we had always the same judge, and she did not really push to make sure that contact happens. Then, after I got to know what's going on, I finally requested people send this case to Luxembourg, even if it was late, to get a preliminary ruling on the interpretation how national enforcement, which is under Brussels 2A, has to be enforced. The Commission always denies that it is necessary. When I look on the Commission, I go very quickly. I have serious questions if civil justice policy should really deal with these cases, because that's a law, and how it has to be interpreted, policy is more, how should I say, a political issue. What I also watched very carefully is the case of Max Schrems. That means safe harbor. And I think he's a real hero, because he managed at the end, even the Commission denied it, that there was a violation. He finally managed to bring a case, and the European Commission has a monopoly. He managed to bring the case to Luxembourg court, and finally he got the answer from the court that the European Commission was wrongdoing for several years, because they still accepted the safe harbor, and nothing has happened. So my request would be, in the case, what does it mean now? I still have parental responsibility. Also, I would want to have immediate access to my child. What I would suggest, because the Commission always denies that there is a violation, to pick up cases on what I call parental root cutting. Either parents have no contact to the child, children are on forced adoption, children are on adoption, or whatever, that we get a ruling from Luxembourg court about this, how an interpretation, how contact between children and parent has to take place. And there is the Charter of Fundamental Rights of the European Union, which comes into the loop as soon international law is involved. Maybe we should consider to put some money in it and to bring some cases to Luxembourg court. For my case, I would see something similar. Then I would want, that's also an interesting point, the Commission itself is not going to Luxembourg court. That's a legal service commission. And we should look at the legal service commission and not the Commission when it comes to interpretation of law. Then big points. Currently there is a review of Brussels 2A, but on this Brussels 2A, there is no information. There is nobody from outside. I suggested or requested that, can I join it, or would somebody from the parliament who joins these meetings, this expert group, but there is no information. And what I would suggest in total is, currently we have this Brussels 2A cases, like this one, like my one. Would it be best to keep all these Brussels 2 cases open until this new suggestion come out, and then we do a reality check on this suggested Brussels 2A law on existing cases, that parents can come back? Sorry, and thank you that it took a little longer.
Thank you very much. And yes, we are running short of time. I'm happy to extend the floor to the Commission representative, Mr. Grubisic, again.
Thank you, Madam Chairwoman, for the floor. Thank you to the petitioner. Thankfully, I think this could be kept short, because up till this point, the Commission has answered close to 20 letters to the petitioner, as well as some 30 requests for access to documents. And the petition at this point does have no new substance that the Commission already hasn't reviewed together with the legal services. The point of this whole complaint is on the application of the Brussels 2A to the petitioner's case, especially concerning the enforcement of Maltese decision on access to the petitioner's child and on the jurisdiction of English courts. Unfortunately, this has already been communicated to the petitioner numerous times. Namely, The Brussels 2A only regulates how a decision, concretely this pertaining to the Maltese decision on access to the petitioner's child, the Brussels 2A only regulates how that decision is to be recognized, declared enforceable, and then enforced in a member state. And when it comes to enforcement in the member state, the regulation is very clear in pointing out that the material enforcement, how the procedure for enforcement should be taken care of, it's up to the national law of the member state. The Brussels 2A is only a private international law instrument. It doesn't have substantive rules for enforcement. And we have knowledge that the UK courts have contacted the petitioner, explaining to him what the backup, what the problem is in the procedure of enforcing that decision. Concerning the jurisdiction of the English courts in the petitioner's case, as the petitioner himself has stated, the courts do have jurisdiction because the petitioner's wife has taken the child illegally to the UK. A certain amount of time has passed, and under the Brussels 2A regulation, specifically Article 10 on the jurisdiction in the case of wrongful removal of the child, UK courts do have jurisdiction. So it's really these 2 points that the Commission can consider, simply because the Brussels 2A is a private international law instrument. It doesn't have anything other than jurisdiction and determining of enforceability and enforcement, no substantive rules. This is precisely why the Commission has not yet contacted the UK, because we can't identify an infringement of these private international law rules. And only on the basis of an infringement or a perceived infringement can the Commission intervene with member states. Thank you very much.
Thank you very much. Highly appreciated. Now, no one has asked for the floor. I'll give the floor back to the petitioner for a very, let's say 1 minute, because you exceeded your speaking time before.
Okay. Coming back to the first point, because it seems the Commission is fed up with my freedom of information requests, I asked immediately also the European Ombudsman to investigate the case. This has never happened. And for example, in 2013, I have written several letters, asked for instructions how to go ahead with this case, what to do in UK when I knew that UK will take jurisdiction. What I know now, at this time, this case should have been sent to Luxembourg for a preliminary ruling on the interpretation of this law. What the Commission is saying, one point is again, sorry, DG Just, I don't think that they have the qualification. Maybe it's more the Legal Service Commission. And from this point, I think it's wrong. The second point, I made a second application on the official way, saying UK should have transferred the case, and that's Treaty on the Functioning of the European Union, and UK rejected completely out of merits. I sent it to the Commission, and the Commission said, no, that's not a violation of European Union law. When you look on the video of Mark Schrems, he said it happens regularly that they don't do it. Thank you.
I take it as you asked for the floor and then took it back. Or do you want the floor? Okay, go ahead.
Sorry, very briefly, I wanted to say that I would like to keep this petition open in order to better get in depth during these during the working group activities in the next year, and to better clarify all those issues that the petition had raised, and because from my point of view it's really confusing. I really need to get more in depth on those issues. And I want just to say another thing. Is there any case in which the Brussels II regulation hasn't been applied by a member state? Does the Commission has ever find a misapplication of, because it seems that every time the Brussels II regulation is or applied or simply to I mean, in a way, basically just a guideline, and nothing can concretely be done. So it's really like something. I mean, I feel like in a circle that never ends. This is the feeling. So if we just keep this petition open, I don't know if the colleagues can agree on that, and we will go much in depth in the next months.
Actually, to tell you the truth, to keep a petition open where the petitioner have been here 3 times, where the Commission have answered in written 20 times in letters, is to maintain a vicious circle, in my view, and to give false expectations to everybody. I mean, there has to be, you know, if you feel that you're going in a circle, then break the circle. Mrs. Pitella, the floor is yours.
Thank you, Chair. And there is no possibility to get out of the vicious circle. The officials cannot find the way out. Adoptions and other issues related to it are very difficult legal problems. In case of a dispute between the parents, there is no way that an official can solve it, because what can they do? Take away the child from the parents? One parent cannot be forced to recognize the rights of the other. So getting a consent between 2 people, a married couple who have divorced, well, it's not a task for officials. It's something for mediators, psychologists, and sometimes it's impossible for them to find a solution. So I just wonder how to solve such problems. Can parents be forced to agree by an official in an authoritative way? Can a court do it? I don't think so. We are pretending that we can do something about it, and it will be another petition that will be kept open until the child comes to age. And perhaps when they are adults, they will have good relations with both parents or with one parent, or they will hate both. So I don't think that our life experience gives us an opportunity to solve this problem.
Thank you very much, Mrs. Pitella. How do I summarize this? I would like really to say that to keep this petition open is not in the interest of this committee. We have had you here, sir, 3 times already. The exchange with the Commission has been ongoing repeatedly with 20 letters. There is possibly nothing more that we as a committee can do. And again, I do not wish to give you false expectations. We have we have exhausted every possibility of coming to grip with your issue. There is nothing more that we as a committee can do. I have heard that Mrs. Evi would like to not have, there is possibly no more information, objective information that can be put into or invested into this. But of course, as a piece of information, we could close the petition and send it to your working group. If you would like to further deal with it, that would be one proposal. And we close the petition, but we close it and as a piece of information to actually move on for deliberate on it on child-related issues. You can have it as an additional thing, but not to open it, but to have it in your file as a material of reference. Would that be a possible way forward? I have already given you the floor, sir. Would that be a possible way forward? I'm looking at colleagues now. Yeah, they are nodding. Mrs. Danoka.
You see, Chair, yeah, I do understand that we had this, but we have voted today for the question, just speaking, that we need in particular better definition of habitual residence. And just to continue this discussion on Brussels II, I think it would be better to keep without false promises, etc., but still keep this petition, because it will be just our argument to prove that here is the problem. And I see the bigger problem, and we know of a number of cases for Britain just in failure to define what is habitual residence in this case. My proposal would be at least up without false promises, but just up to discussion in plenary on Brussels II, and all subsequent steps to keep it still open. It would be my proposal to, and I am also a member of this working group, so to examine it in the status of still pending petition. It would be better, by my opinion.
I think it's very difficult, this kind of case, but I think your solution is possibly the best solution on the basis of what we've heard from the Commission and from you as the petitioner and the current state of the case. I think it would be fair. I really agree with what Mrs. Petira said about not giving false hope to people. And I think, you know, all of the petitions which have come in over the years, which are about how child protection cases are dealt with in the UK or have a UK dimension, those are going to inform the work of the committee following on from the fact-finding visit to London and what comes out as a result of that. So I think that will be feedback in the future, but to keep the petition open, I just think it raises a false hope of something that we'll be able to deliver from the Parliament beyond those broad, that broad feed into a policy process, which surely is what we should be trying to aim for.
Thank you very much. Beatriz.
Gracias, Presidente.
Thank you, Madam. I just want to add that I agree with your proposal. I think that our openness is all about the transparency with which we provide solutions. We, of course, have the need to provide responses to petitioners when they bring issues concerning children to us. And I think that in our agenda and in the work that we do in our political groups, when it comes to children, it's important that here in the Petitions Committee, children's rights and well-being are at the forefront of our work. When we're looking at this and concluding the process and talking about closure of this petition, that doesn't mean that we're going to stop working on these kinds of issues. We will be trying to make progress with the issues as a whole, but this current petition, I think, is going round and round in circles, and I think what you've put forward is the right decision.
Mrs. Pitera?
I have a question. Are the children unhappy? Because we don't really know whether the children staying with their mother are unhappy or are happy. We don't know their situation, and I would be very interested to know whether they have a home, whether they have a chance to develop properly, whether they enjoy good care, whether they are healthy, whether they have food and education. Maybe they cause a problem that needs a professional advice. We don't know. We only know the dispute from the perspective of one of the parents, and I would like to know how the children are doing. Maybe we could ask a question, whether the social services know if the children are cared for. Because I wouldn't like to take part in a dispute between two adults. I'd rather know whether the children are happy, because they have full rights, even if they are little.
Cinque Barza. That's a very good point, and it really brings about the whole, let's say, the cornerstone, the well-being of the child and the individual child. I have now listened to colleagues, and I also think I have a say in this, and I would initially I had the intention of closing the petition. After all, the petitioner has been in 3 times, and as we have said, everything has been exhausted. There is not a miracle cure out of this. Nevertheless, having listened to colleagues, I think that the best way forward would be still to close it, but after having closed it, send it as a point of reference to further deliberation in the working group for their consideration when they move on with their report. And I think that could be a possible way forward. Eleonora, very shortly.
I just wanted to add something. I can't really agree with what has been said by Mrs. Pitera, simply because we can't investigate the situation of minors. So that would draw us into an area where we simply don't have competence. We're here to make sure that the rights of both parents to see their child or children are respected. So I would take for granted here that we are talking about the well-being of children, and that's uppermost in our minds, but we shouldn't get drawn into an area which isn't part of our competence.
Interpreted Mrs. Pitera's intervention as, a human interest in the whole field. And I need to underline that what we are seeing here is one side of the coin. There are 2 parents in this case, and we have seen one side of the coin repeatedly. We don't know anything about the children or the mother. This has to be taken into deep consideration by everyone in this room at this moment. So I'm asking now, colleagues, can we do this, that we actually close the petition finally, and as a material or reference, we move it for information and further deliberation for the working group on children welfare? Yes, 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 even, yeah, good. That's what we do. Thank you very much. And to the petitioner, I gave you already the floor and we're running late. I'm sorry about that. We need to conclude on this, and I thank the petitioners for having been with us, and you are now free to leave the room because we are moving to the next item on the agenda.